Got my assistant in here, Your Honor, just in case we have any technical difficulties.
That's good
Because
to know.
I am totally unequipped to handle them.
Well, I'm proud of you. You got on Zoom.
Yeah.
Okay. This is, pardon me if I massacre this, Gavrilides Management Company et al. Versus Michigan Insurance Company, docket number 20-258CB. And this is the time set for Defendant Michigan Insurance Company's motion for summary disposition. And just for the record, could I have your appearances, please?
Yes, Your Honor. Matthew Hios and Nick Gavrilides is here in the courtroom also with me. He's the owner of the plaintiff companies.
Henry Emmerich on behalf of Michigan Insurance Company, Your Honor, and my assistant, Chenny Ward.
Okay, thank you. And your motion, Mr. Emmerich, if you wish to go ahead.
Thank you, Your Honor. I'm going to assume that the court has read all of the pleadings in this case, so I'll try not to belabor some of the points. I think the key fact here that we need to focus on, as we've argued, is that there's little question here, but the policies that insure Mr. Gavrilides' properties against direct physical loss or damage to the property, and contrary to any claim that the policy benefits in questions, this business income coverage is illusory. The policy in question here clearly provides that for the business coverage, the business income coverage to apply, and most of the other primary coverages under the policy, there must be a direct physical loss of or damage to the insured property in order for it to apply. And I think it's important, as we'll discuss later in our argument, depending on what Mr. Hios has to say, why this is important. We must focus on the fact that there must be direct physical loss or damage to the insured property, and not direct physical loss of use or damage to the property, as has been suggested by Mr. Gavrilides and his attorney, in order for the coverage at issue to apply. While we acknowledge, Your Honor, that this is a somewhat unique, extraordinary, if you will, matter to be filing at this point in the proceedings as our initial pleading, I think it's important to understand that when we look at Mr. Gavrilides' complaint, it does not contain one single allegation that this insured property has in any way been damaged or lost. To the contrary, the allegations in the complaint affirmatively allege that the plaintiff's business interruption claim is based on the stay-at-home orders of Governor Whitmer. There is no allegation of any kind that the property in question has in any way been damaged, lost, or anything of the sort. Given that this motion has been brought under 2.116 parent C10, plaintiffs must produce some evidence to contradict the uncontroverted facts that have been alleged not only in the complaint, but in the affidavit submitted by Mr. Gavrilides and any of the other materials that Mr. Hios has attached to his response. As indicated, most importantly, the affidavit from Mr. Gavrilides that reiterates the admissions in the complaint that there has not been any loss of or damage to either of the properties for which they seek coverage. The insured's property today exists in the very same condition as they existed the day prior to the effective date of the stay-at-home order. They have not been lost. They have not been damaged. They have not required any repairs because of any damage to those properties. The business operation, its operation as a restaurant today is the same as the day prior to the effective date of the order, albeit with some modifications that have been required to avoid grouping and to maintain social distancing. In a sense, improvements to the real estate, not repairs, and it's been maintained as a takeout operation, at least until recently, when they resumed the dining operation. There has been no loss of or damage to either building that has prevented the plaintiffs from operating as a restaurant or entering it, for that matter, as they have. If plaintiffs wanted to sell either building today, they could do so. And while plaintiffs have provided some speculative evidence about the decreased value of that property, although as I read the Deloitte materials that Mr. Hios kindly attached to his response, the fact of the matter is, as pointed out in that article, is that while the operation of a commercial property may get harder, it's not impossible to operate it in the future under our new normal. Because plaintiff's complaint, the affidavit, the other information that has been provided to your honor provides no evidence of any damage to that property, plaintiffs could never prove that either property suffered any direct physical loss from the imposition of Governor Whitmer's emergency order, and thus could never recover business interruption coverage under this policy based on the facts that have been presented to the court. The same holds true under the business income coverage if a civil authority prevents or prohibits access to either property because of direct physical damage to an adjacent or nearby property for the very same reason. There has been no direct physical loss of or damage to any adjacent property that has been alleged, that has been provided to the court in Mr. Hios' response. And frankly, when you look at the order that they have, that is at issue in this case, there's nothing there that prevents access to Mr. Gavrelati's properties whatsoever. In summary, Your Honor, there are no facts alleged in the complaint or in any of the materials that I've looked at, including Mr. Gavrelati's affidavit, that shows there has been direct physical loss of or damage to the insured property. And for those reasons, Your Honor, we believe our motion, on those reasons alone, we believe our motion for summary disposition should be granted. I'd just like to make a couple of additional points before I shut up on why we believe summary disposition is warranted on this basis alone. And I refer to the case that we've discussed in our brief, Your Honor, that's referred to as Universal Insurance Productions versus Chubb. And that's a decision of the Eastern District of Michigan involving a claim that involved insured property was damaged by a pervasive odor that developed in the property as a result of mold that grew in the property because of some water seepage. And why that case is important is because it discusses the Michigan rules of contract interpretation that still apply today if policy language is clear and unambiguous on its face, which we believe is clearly the case here, that states that the words and the terms of the policy should be enforced utilizing plain and commonly understood meanings. And when I said earlier that that's important when we talk about what direct physical loss of or damage to property means, it means we look at those words. We don't add words such as loss of use that Mr. Hios and Mr. Gavrelatis have added in order to understand what we're talking about here. We look at the language in the policy. Every case that Mr. Hios produced, Your Honor, says the very same thing. In Universal, like here, the policy was an all-risk policy that required, like here, direct physical loss or damage to the insured property in order to trigger coverage, unless that coverage was excluded. As Universal pointed out, applying a dictionary meaning of direct and physical as meaning something immediate or proximate, as opposed to something that is distant or incidental, and physical meaning something that has a material existence, meant in the context of a loss involving a contaminant that, unlike here, per the uncontroverted allegations of the complaint and other evidence produced by plaintiff in response to this motion, that in order for direct physical loss of the property in this context, the contaminant must actually alter the structural integrity of the property in order to trigger coverage under language that is at issue in this case. And it didn't happen in Universal, as the court denied coverage there, granted affirmed summary disposition. And importantly, Your Honor, it hasn't even been alleged in this case. Regardless of any authority to the contrary anywhere else in the country, this remains the law in our courts when interpreting policy terms at issue. There's a requirement that there be direct physical loss of or damage to property. And the allegations adduced here in the complaint and the evidence that's been attached have specifically acknowledged no such contamination and no such damage to the property as a result of that contamination. As in Universal, Your Honor, the mere presence of odors or even mold was not any evidence of structural or tangible damage to the insured property. And as such, no direct physical loss of damage to the property occurred. Here, Your Honor, we have the very same thing, except that we have not even had any allegations of any damage to the property caused by this horrible virus. Finally, and although we do not believe the court even has to get to this point, even if we assume for purposes of this motion that contamination occurred on each premises and that somehow affected the structural integrity of either building, again, neither scenario is alleged. And even if it were, we do not believe under the circumstances and the science that exists that it would necessarily constitute direct physical loss of or damage to the property. The virus exclusion of the policy, which clearly and unequivocally states that it applies to all coverages and endorsement, and that the company will not pay for loss or damages caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. And Lord knows that that has certainly been the case with what's happened with COVID-19 throughout our country. Clearly, Your Honor, that exclusion, again, we don't believe you even have to get there, but that exclusion would clearly exclude any claim here, even if plaintiffs could prove direct physical loss of or damage to the insured property or any nearby property that resulted in a civil authority issuing an order prohibiting access to the property. As of 8 days ago, Your Honor, there have only been 2 jurisdictions in this country, Florida and Pennsylvania, that have discussed and applied a similar exclusion as at issue in this case. And in every one of those cases, the court has enforced that exclusion as written because it's clear and unambiguous. Again, Your Honor, for all of the reasons that we've set forth here today in the brief that we filed and our reply, we request that the court grant our motion for summary disposition at this time. Thank you.
Thank you. Mr. Hios?
Thank you, Your Honor, and may it please the court. Obviously, Mr. Emmerich and I have a different interpretation of direct physical loss of or damage to covered property, because here the loss comes from the issue of the executive order restricting the use of the property. Physically, you cannot use for dining services any of the interior of the building for a period of time. And a complete prohibition isn't contemplated by the language of the contract. I think a limited restriction also falls within the coverage. And I think that you're going to accept the defendant's argument, you would have to limit the meaning to destruction of the physical building itself. But we know that the coverage extends to non-destructive losses, civil authority being one. I put in the example in the brief of subterranean pollution. You could look at asbestos or the computer virus as something that would occur where there would be no physical destruction to the property itself. The fact of the matter is that Mr. Gavrielides can't use the covered properties because of, or he's lost rather, the use of those properties because of the order. And it looks like that will continue in some form for a while. And so I think that the council is wrong in trying to limit the scope, even with the case law he cited, most of which is persuasive and not binding on the scope. That's number one, Judge. As for the virus exclusion itself, the only case law we have relates to person-to-person transmission of a virus at the covered property. And I think that fits more with what's going on. We see in the news that Harper's in East Lansing, and even the Hopcat in Kalamazoo is making headlines of people contracting COVID there. But the impetus of the order was to protect public health and welfare, which is the governor's duty. It's not caused by a virus. It would be the same order as with the dam in Midland being issued to protect public health and welfare. It wasn't caused by a flood. It was caused by the governor's duty to act to protect the people she's in charge of protecting. And I think that's what's happened here. And it's distinguishable from the case, and I think it's Kogler, the case cited regarding the virus exclusion. And I think that if you go further in accepting defendant's position, then we get into the illusory promise of, well, if a government issues an order, we're not going to cover it because any decision of a government body or a group of people is excluded. And so there you get into the circle in the contract where if you're really going to buy into counsel's logic, it would make that provision illusory. And for those reasons, I think that the motion should actually roll back on the defendants because the language supports their claim. And to the extent that the court thinks there's a deficiency in my pleading and is going to grant defendant's motion, then I'd like leave to amend the complaint. But I don't think that's the case here. And with that, I'll leave it back to the court. If the court would like to ask me any questions, I'm happy to take them.
I don't have any, thank you. I'll give Mr. Emmerich rebuttal time.
Thank you, Your Honor. Your Honor, what I would say is that when we talk about these cases that Mr. Rios has mentioned that might provide coverage in certain situations, I read those cases a little while ago, and I'm kind of tired of reading some of these cases about insurance coverage. But the point in every one of those cases is that the conditions he referred to actually caused damage to the property. In this case, there has not been any such damage. And if we look at what the coverage for business loss or business, the business income loss that they're seeking says, it says that if the business, that coverage would apply if the business operation is suspended, provided the suspension must be caused by the direct physical loss of or damage to property. In this case, that hasn't occurred. Nothing prevents Mr. Gavrolatis from using that property. It has been used as such. The fact that there may be other coverages that may provide some limited coverage goes against what Mr. Rios is arguing, because clearly if those coverages were covered under this language, then why have a special coverage that provides certain conditions for its application? The point is, in each of those civil authority cases that he talked about, the property actually sustained damage. Here it didn't sustain damage. As to his claim, in this case, that he wants an opportunity to amend his complaint if the court feels compelled to grant my motion, what is that going to accomplish? He's already alleged in his complaint, and his client has already signed an affidavit where he no doubt put his hand up and swore to the contents of that affidavit, in which he said there has been no damage to that property. We don't create coverage because somebody thinks they ought to have coverage, but that whole line of cases, Rory versus Continental Insurance, and some of the other cases in our brief that we cited, clearly support the notion that the reasonable expectation concept doesn't apply in Michigan. It just doesn't cut it. There is no coverage here, Your Honor. That exclusion is clear if the court feels that there may be, or that there may be a situation that would give rise to it. But again, you have to come forward at the time that you respond to this motion with some evidence to suggest that. That hasn't happened here. I mean, even when you look at the response that he's filed, he talks about scenarios that have absolutely no bearing to this case. And, you know, I'll just make one last point, Your Honor. You know, when I was a young prosecutor, I had the benefit of being able to argue a number of cases to juries that required me to prove the defendant's guilt beyond a reasonable doubt. And in those cases, I was trained to listen closely to the defendant's argument. And if in a case where the facts were particularly egregious, the defense attorney would often not even talk about those facts and talk about the law. And he talked about how that law was somehow created this reasonable doubt in hopes of creating some confusion on the part of one juror who might then find in his client's favor because reasonable doubt existed. And in those cases, I would make sure that when I got up in rebuttal, just as I have been given the opportunity to here, I would point that out to the jury and indicate to them that there was a reason for that. And that's because they didn't want you to talk about the facts that clearly supported conviction. On the other hand, it was a case where the law, you know, or the facts may have been murky, but the law was clear. The defense attorney would only focus on you know, on those facts and not talk about the law. And again, I'd point that out to the jury there. But in this case, you know, and there were cases back then too, like our case here, that were neither supported by the facts or the law, which I believe is clearly the case in this case. And the defense attorney would get up and argue something that to the jury that had absolutely nothing to do with the case in hopes of confusing them. Just like Mr. Rios has suggested by talking about these asbestosis cases or some of these other cases that have nothing to do with this. Or in this case, when you look at his responsive pleading, he talks about an accident situation that has absolutely no application here, nothing to do with this case. Or in his argument, he starts out talking about a discussion of the virus of racism. And as there, we would point out, if we were in front of a jury, just like I had to point out to them, and I'm pointing out to you, it hasn't got anything to do with this case. Your Honor, the reason for that, the reason for him to talk about that is that he knows that neither the facts or the law support his claim. And nothing he could file as an amendment would change that. He is hoping to somehow create this little bit of possibility, some scintilla that some evidence is going to pop up that shows that the property has been damaged, and hopes that he could trigger coverage. And as this court knows, under the cases we've discussed in our brief, that is not sufficient to deny summary disposition in a case that clearly warrants it, even at this early stage. Thank you, Your Honor, for your patience. Thank you, Mr. Rios. We've never met. I've heard a lot of good things about you. Mr. Gavrolatis, nice to have met you. Very sorry for the situation you're in. It's just crazy all the way around. And just like having to argue this case on TV is really disconcerting for me. But in any event, thank you, Your Honor, for your patience.
Thank you. You're on YouTube, not TV, but. Oh,
I meant screen. Yeah, whatever.
Right.
The screen.
I did read the briefs. I studied them very carefully, and I listened to the argument of counsel today. And taking all of that together, I note that the plaintiff speaks of and focuses on arguments about access to the property, use of the property, and definitions of loss and damage. But the first inquiry has to start with a full look, not just isolating some words or phrases from the policy, but a full look at the coverage that's provided under the policy. Coverage is provided for actual loss of business income sustained during a suspension of operations. The policy goes on to provide the suspension must be caused by direct physical loss of or damage to property. And it also provides the loss or damage must be caused by or result from a covered cause of loss. The causes of loss special form provides that a covered cause of loss means risks of direct physical loss. So whether we're talking about the cause for the suspension of the business or the cause for the loss or the damage, it is clear from the policy coverage provisions that only only direct physical loss is covered. Under their common meanings and under federal case law as well that the plaintiff has cited that interprets this standard form of insurance, direct physical loss of or damage to the property has to be something with material existence, something that is tangible, something, according to the one case that the plaintiff has cited from the Eastern District, that alters the physical integrity of the property. The complaint here does not allege any physical loss of or damage to the property. The complaint alleges a loss of business due to executive orders shutting down the restaurants for dining in the restaurant due to the COVID-19 threat. But the complaint also states that at no time has COVID-19 entered the soup spoon or the bistro through any employee or customer, and in fact it states that it has never been present in either location. So there simply are no allegations of direct physical loss of or damage to either property. The plaintiff seems to make, in the briefing at least, two arguments about the language in the coverage provision and what it means. The first argument is that the plaintiff says coverage applies to, quote, direct physical loss or damage to property, end quote. Even if that were the wording of the coverage provision, it wouldn't save the plaintiff from the requirement that the loss or damage must be physical, and the analysis could end right there. But I have to go on to say that that is not even the wording of the coverage provision. Coverage, according to the policy, applies to a suspension caused by, quote, direct physical loss of or damage to property, end quote. So I'm not going to get into a detailed analysis of the rules of grammar, but common rules of grammar would apply to make that phrase a shortcut way of saying, quote, direct physical loss of property or direct physical damage to property, end quote. So again, the plaintiff just can't avoid the requirement that there has to be something that physically alters the integrity of the property. There has to be some tangible, i.e. physical, damage to the property. Then the plaintiff, in the briefing at least, seems to make a second argument that, and this is not 100% clear, but it seems like the plaintiff is saying that the physical requirement is met because people were physically restricted from dine-in services, but that argument's just simply nonsense, and it comes nowhere close to meeting the requirement that there has to be some physical alteration to, or physical damage, or tangible damage to the integrity of the building. So the next argument that the plaintiff makes is that the virus and bacteria exclusion is vague and can't apply here. The plaintiff has not adequately explained how the term virus is vague, and in fact supplies a completely workable, understandable, usable definition of the word virus. The argument in this regard really seems to be more that the virus exclusion doesn't apply, and it goes something like this as far as I can tell. First, a virus can't cause physical loss or damage to property because viruses harm people, not property. Second, the damage caused here was really caused by actions of a civil authority to protect public health. And then third, therefore, coverage for acts of any person, group, organization, or governmental body applies. But that argument brings us right back to the direct physical loss or damage requirement. Again, going back to the causes of loss, special form B as in boy, exclusions, provides that acts of government are only covered when they result in a covered cause of loss. A covered cause of loss, again, is direct physical loss. So even if the virus exclusion did not apply, which the plaintiff has not supported that it doesn't apply, I only argued that it's vague, which I reject. But even if it did not apply, there could only be coverage for governmental actions that resulted in direct physical loss or damage. And then finally, the plaintiff argues that the policy has a contradiction in it that renders it illusory. So the plaintiff says that the policy extends coverage for governmental acts, but then it takes it away in the causes of loss special form. But that's simply not true. Coverage is provided for actual loss of business income sustained during a suspension of operations. However, according to the coverage provision, the suspension must be caused by direct physical loss of or damage to property. And governmental acts are likewise covered if it results in a covered cause of loss, which is, again, a direct physical loss. There is no granting of coverage and then excluding the same coverage in the policy. As a matter of fact, the policy is consistent throughout and consistent with the federal law cited by the plaintiff. It requires physical loss or damage. There is a virus exclusion, even if plaintiff was alleging, even if there were allegations in the complaint alleging actual physical loss or damage, which the complaint does not do. But there is a virus exclusion that would also apply. And governmental action that results in direct physical loss is covered, but again, there is no direct physical loss alleged here. Now, I had to address a little bit this, that it was brought as a C-10 motion. Actually, the defendant hasn't provided any support by way of factual support, depositions, affidavits, etc., for a C-10 motion. So if the defendant doesn't do that, then the plaintiff has no burden under Maiden versus Rosewood. So there's no shifting burden until the moving party first does it. But I don't think it properly is labeled a C-10 motion. I think it's a C-8 motion, because this is a motion that can be decided as a matter of law. Take all the allegations in the complaint as true and examine nothing more than the contract upon which the complaint is based, the policy of insurance, and as a matter of law, the plaintiff's complaint cannot be sustained. And although the plaintiff has requested a chance to amend without any indication of how they would do that, there actually is no factual development that could change the fact that the complaint is complaining about the loss of access or use of the premises due to executive orders and the COVID-19 virus crisis. So there's no factual development that could possibly change that, or amendment to the complaint that could possibly change that. Those things do not constitute the direct physical damage or injury that's required under the policy as I've outlined. So for those reasons, I am granting the defendant's motion for summary disposition. I'm doing it under MCR 2.116C8.
Thank you, Your Honor.
Mr. Emmerich, will you submit an order?
Certainly will, Your Honor. Thank
Okay.
you.
Thank
Thank
you.
you very much.
That will conclude our hearing.
Thank you.
Thank you.